Hello, and a very warm welcome to everyone who is joining us today. My name is Katerina Aristova, and I'm a postdoctoral fellow at the Bonavero Institute of Human Rights. And it's a great pleasure and an honor for me to chair such a distinguished panel of experts who are going to discuss the intersection between transitional justice and corporate accountability for human rights violations today. We are very lucky to have today with us Irene Petrapoli, Maha Abdallah, Oini Ape, Helena Aparak, Nadia Bernas, Jonathan Coley, and Marco Velasquez Ruiz. Some of the speakers are joining from tricky time zones. We really appreciate this, and I'm delighted to see everyone. I will also introduce each panelist in further detail in the course of the event. We have also received apologies from Dr. Tara Van Ho from the University of Essex, who unfortunately couldn't join us for a good reason today, but Tara, you will be missed. This webinar is hosted by two networks, Oxford Business and Human Rights Network and Oxford Transitional Justice Research. Many colleagues and friends helped with organizing this event. Thank you very much to all of them. The inspiration for today's discussion is publication of the book Business, Human Rights and Transitional Justice by Irene Petrapoli. This is a very important contribution to the existing scholarship in the field, which examines the efficacy of transitional justice mechanisms in response to corporate abuses, business-related human rights abuses. Transitional justice mechanisms such as trials, truth commissions, and reparations have usually focused on state and non-state actors directly linked to the stakes, but some innovative mechanisms have developed which try to provide for the redress for victims of business-related human rights abuses, and our panelists will consider these developments and also share some experiences and insights from Africa, Latin America, and Middle East. Before I give floor to the speakers, one last thing to mention is housekeeping rules. We are going to have Q&A session later on. You can see the Q&A button at the bottom of your screen. Please type your questions and we'll try to address as many questions as we can. So without any further delay, I'm introducing the author of the book. And I'm going to read the biography because I don't want to miss any of the amazing things that you've done, Irene. So Irene Petrapoli is a research fellow in business and human rights at the British Institute of International Comparative Law. Prior to joining BICL, Irene worked with international organizations and NGOs in different countries of Europe, Latin America, South and Southeast Asia. And she worked as a business and human rights consultant in Myanmar and as a senior researcher at Business and Human Rights Resource Center. Irene, congratulations again with this very important achievement. And we're delighted to have you and looking forward to hearing from you.
Thank you very much, Katerina. Thank you for the introduction and the very kind word. Well, I had the bad luck of releasing my book in May 2020, so in the middle of the first lockdown. So, of course, I miss a book launch, which is one of the few things that I was looking for when I started my PhD. Sorry, Nadia was my supervisor. So when Katerina contacted me and kindly offered to organize this launch, I was delighted. So many thanks to the Bonavero team for this initiative. Too bad that we are missing a drink reception afterward, but it's so important that we have today such a diverse panel with experts joining us from Colombia, from Palestine, from South Africa, Australia, and Europe as well. This is so important to have people from around the world because the topic, business and human rights and transitional justice, is of course a global issue. It is an issue of international law. Corporation often operates in countries affected by conflict or repressive regimes and are often involved in human rights violation and crimes under international law, either as the main perpetrator or as accomplices, aiding and abetting government forces. When I started my doctoral research that, well, like a number of years later has resulted in this book, I was already interested in the issue of corporate human rights abuses in conflict areas. At that time, I was working for Business Human Rights Resource Center, working at their conflict portal. And then I moved to Myanmar, where I spent the following 3 years there. A country that is sadly notorious for the involvement of both private and military-owned company in the conflict there and serious human rights violation. It's also a country where transitional justice has not been on the agenda of the new government after the transition. So I started to explore the links between those two fields, business, human rights, and transitional justice. At the time, There was only one book edited by Sabine Michalowski. Tara couldn't join today. She had a chapter in the book, an edited book that compiled different cases. But at that point, the research and practice had mostly focused on one specific country. Mostly was South Africa, and then more recently Argentina and Colombia, or one specific mechanism, for example, the Nuremberg trial against the German industrialists, or the South Africa Truth and Reconciliation Commission, one type of right violation, or one specific issue, for example, the unlawful corporate exploitation of natural resources. So I decided to look at the issue in a comprehensive global manner, analyzing how the typical transitional justice mechanisms, which are judicial processes, truth-seeking initiatives, reparation program, and institutional reform, have dealt or failed to deal with corporate human rights abuses, and whether they have provided remedy for victims. In transitional justice context, the trials through commission and reparation typically included within the set of remedy mechanisms have focused primarily on abuses by state authority. But innovative use of transitional justice across the world have started, in the past few years, have started to address, even if still only in a marginal way, corporate accountability for human rights violation, and have also attempted to provide redress for victims. So within this framework, the book here, this book, is divided into chapters, each assessing how the four processes that constitute the core of transitional justice, so judicial mechanisms, truth-seeking initiative, reparation program, and institutional reform, have achieved corporate accountability and remedy. So our panelists today will provide comments, not on the book, but on the different aspects of this mechanism. So really we're going to have more like a panel discussion than a book launch, but I just want to give a few remarks. First, that transitional justice, corporate accountability, and their goals are linked and overlapping, as both fields of transitional justice and corporate accountability are expanding. They may arguably also converge. Transitional justice aims to achieve justice, to establish the truth, provide reparation, and corporate accountability share some of the same aims. Both transitional justice and corporate accountability are continually developing. Transitional justice has moved away from a narrow focus on the most serious civil and political rights violation committed by state actors, to include also economic, social, and cultural rights, and then explore economic violence such as corruption and the unlawful exploitation of natural resources, to finally lately consider also the role of corporations. For example, in Argentina, in the 80s, the first true commission, the National Commission on Disappearances of Persons, was mandated to investigate only cases of enforced disappearance during the dictatorship there. Now, the courts in Argentina are investigating the role of multinational companies in the repression and their complicity in the crimes committed there. And then, simultaneously to the expansion of transitional justice, also the business human rights field is developing. While international human rights treaty impose obligation only on states, it's now accepted that corporations do have responsibilities in the area of human rights. The international legal framework is developing accordingly, and at the moment an international treaty on business human rights is under negotiation at the UN. Also, although the path has not been a linear and smooth one, criminal and civil litigation alleging corporate involvement in past abuses in both the home and host countries is also being incessantly pursued. Currently, impunity, we can say, is still the norm, and cases resulting in corporate accountability are few and far between, but progress is in the direction of more accountability, not less. For example, last September, French prosecutors have opened an inquiry into PNB Paribas over claims of complicity in crimes against humanity, genocide, and torture in Sudan. So I believe that transitional justice cannot be holistic if it overlooks the responsibility of company. Bringing the economic perpetrators and accomplices that made many of the violations possible into the orbit of transitional justice will actually provide for a more complete and holistic justice. The UN Working Group on Business Human Rights has just released a report on business in conflict areas to the UN General Assembly, addressing also the issue of transitional justice. In the report, the working group said that I'm reading from the report that those who design transitional justice mechanisms should acknowledge the business have a responsibility to remedy their past behavior. One way to conceptualize synergy between the business human rights field and transitional justice framework is that the 4 pillars of transitional justice, each of which represent a form of substantive remediation, should be recognized as an inherent part of the remedy pillar of the guiding principle. Also, as a final point, I want to say that unfortunately, often the power versus justice dilemmas of society in transition are one of the main obstacles to corporate accountability, because the investment in economic activity that corporation, especially multinational corporation, could bring to a country in transition may be more appealing than the need to provide redress for violation committed by a company. Transitional government, often reliant on revenues generated by corporate entity, have an interest in non investigating or prosecuting corporation. For example, in Myanmar, conscious of the need to harness the economic power of well-connected businessmen and attract for investment, the new government had accepted leaving the past unaddressed. Transitional society have both weak legal government and fragile legal system. So the attraction of foreign investment seems an easy short-term solution to meet pressing economic need, but it is often corporation and not the host state that ultimately benefit from such lax standards. So even if corporation may play a critical role in fostering the economic progress needed to bring society out of the risk of falling back into conflict, this is not a sufficient reason to trade a contribution to economic recovery with immunity from accountability. I believe that in order to address the root causes of conflict and repression, it is fundamental to consider the role of all actors, including corporation.
Thank you very much, Irene, for outlining this many debates that I'm sure will be picked up by other panelists and possibly during the Q&A session. Our next speaker is Dr. Nadia Bernaz, who is an associate professor of law at Wageningen University in the Netherlands and a visiting professor at Catholic University of Lille in France. She is the author of the book Business and Human Rights, History, Law and Policy, which was ranked as one of the best human rights books of all times by Book Authority. And she founded and runs Rights as Usual, a blog dedicated to business and human rights. Nadia, it's great to have you, and the floor is yours.
Thank you very much, and thank you for inviting me. Of course, this book launch is very special for me. Irene, as she hinted at, was my PhD student when I was in England at Middlesex University. And essentially, we've been working together for a decade. So it's very special for me to be here. Obviously, I have many stories. I'm not gonna get into any of them, because this would be more the time to do it at the drinks, and we're not going to have drinks, so I'll keep the stories for another time. But I just want to say one thing that I think stands out, and it also relates to the book. I've always been very impressed by Irene's clarity, both in writing and also in her, when she talks about these issues that we all care about. And this clarity that she has in her writing, I've had many opportunities to see it, to me is very important, and it really comes out of her clarity of thought around those issues. And clarity of thought comes from a lot of work, a lot of reading, digesting all these issues, and then putting them on paper. So I'm hugely inspired by that. So I just thought I'd mention it because it does relate to the book. And preparing for this, of course, I read parts of the book again. Of course, it's loosely inspired from your PhD, but it's not exactly the same thing as it should be. So yeah, read the book if you haven't. I think it's really worth it. It's a great experience. So I was asked to discuss prosecutions as a transitional justice mechanism. And of course, to me, what stands out the most when speaking about this issue of corporate prosecutions in transitional justice environments is how few cases we have to look at. And I think the book describes these, what I would call isolated prosecutions of either corporations or business people in the aftermath of conflict or of a dictatorship or authoritarian regime. And we have very few prosecutions to look at, and this is so despite what we know of numerous examples of corporate involvement in the commission of international crimes that would normally warrant prosecution. And many examples of this involvement are described in the book in some of the cases that Irene looks at. Issues of enabling regimes, providing loans, providing equipment, providing software to certain actors who then use all of that to commit international crimes. Just the profiteering from slave labor, from weak institutions, from apartheid, and as also is described in the book. And then more recently, as Irene was mentioning Myanmar in her introduction, we've all seen most recently Facebook acknowledging its some form of responsibility in the genocide that took place in Myanmar, and to some extent that is still continuing today. So this involvement, however we want to call it, it exists, it is there, and yet when we look at transitional justice mechanisms, we don't, with some exceptions, which of course Irene describes very well in the book, with some exceptions, but there is no corporate liability that shows at the scale that would be needed if we really wanted to acknowledge the corporate involvement in such crimes. So I think for me, part of the discussion has to be, why is that so? Why do we have so few prosecutions when we know this involvement is a reality? And there's of course a few elements that can be said about how to answer this question. Part of it is because of the challenges of international criminal justice anyway, without even going into corporate accountability. We all know of the difficulties of the ICC as an institution and its limitations, its limited political maneuver, the challenges with the Security Council, etc. So this is challenging anyway, even without talking about corporations. But talking about specifically about prosecution of corporate actors, I think those prosecutions also don't happen because they are particularly challenging. They're costly. Those allegations need, if you use the criminal law route and prosecutions, those allegations need to be proven at a high standard of proof, as is the rule in criminal proceedings and as it should be. But of course, the flip side is that that takes a long time. And the elements that you need to gather to make a case and to actually have a chance at an outcome for corporate accountability, those chances are very low. They also take a long time. So, you know, I think the dearth of prosecution is not because for lack of corporate involvement in those crimes, but because of the challenges that any system would face in prosecuting those, whether it is at the domestic level or even worse at the international level, with even perhaps institutions that have their own challenges anyway. I think another, and I'll probably finish on that, another limitation and perhaps another reason why prosecutions haven't been that many is because international criminal law is conceptualized, has been conceptualized so far as a way to ensure that those most responsible are prosecuted. So the masterminds, the political leaders, the ones who orchestrated massacres, crimes against humanity, or military commanders who made those decisions, who were in a position of authority, that has been the focus of international criminal law to date. And of course, this sits not very well with how we imagine corporations being involved, you know, with a banker somewhere in a London office signing a loan for a particular country. This sort of decisions that are made that don't fit, I think, with the narrative of international criminals. And because of limited resources, international criminal law has focused instead on, let's say, the more the crimes that relate most closely to our idea about international justice, the Nuremberg trial, etc. Whereas corporations' involvement in crimes is more a secondary liability, aiding and abetting. This is how usually the business world would be responsible. I don't know if we want to change this, because I'm personally I have my reservations as to whether prosecutions is the way to go to address corporate accountability in transitional justice settings. I really look forward to hearing what others have to say, also the regional perspective on that, because I suspect the answer will depend indeed on the context. But so far, to summarize, we have very few of those cases to look at. At this point, I really view it as a symbolic issue, that I think we should move towards that. But I'm not sure in practice, if we set up these mechanisms as prosecution, they would actually be used. I still think it would be worth it. But I'm not sure it would make a concrete difference. I think the other modes, mechanisms of transitional justice are perhaps better suited to deal with the kind of behavior that is at stake here, coming from corporate actors. I have completely lost track of the time, so I'm going to stop here and look forward to hearing everybody else and to the questions as well. Thanks.
Thank you very much, Nadia, and you're absolutely fine with the time, no worries. And thank you for outlining these many challenges associated with prosecutions. Our next speaker is Dr. Elena Aparat, who is a member of the UN Working Group on Mercenaries, and she is an expert on international criminal liability of corporations for international crimes. As a field worker and legal advisor, Elena worked in several conflict areas, and she is currently coordinating corporate crimes investigation in conflict-affected country in Africa, and is part of a team investigating corporate climate change-related crimes in a conflict-affected country in Asia. Elena, the floor is yours. You're on mute.
Is that all right now? Okay. Thank you. So, ladies and gentlemen, dear colleagues, I would like to thank Bonavera Institute of Human Rights and Oxford Transitional Justice Research for organizing this panel and allowing us to discuss this newly published book by Dr. Irene Pietro-Paoli. I would like to express my warmest congratulations to Irene for her book, and thank you for inviting me. I would also like to greet all our distinguished panelists and of course all of you who joined us from all over the world. So I was asked to present the truth-seeking mechanism, which I will now try to do through two different aspects. One is about examining the traditional transitional justice system, transitional truth-seeking mechanisms. And in my second part, I would like to present the people's tribunals and their contribution to the truth-seeking. Now, the traditional truth-seeking process is very much state-centered. As Irene rightly pointed out in her book, there is no unique definition of transitional justice. There are different, and I quote her, sets of measures to deal with legacies or violations that occur during armed conflict or under other authoritarian regimes. While the practice related to transitional justice has older historical roots, transitional justice as an autonomous discourse emerged mostly after the Cold War. Therefore, its characteristics are primarily based on the modern international law. Regardless of the definition that we may give to the transitional justice, the objective of transitional justice is the reconciliation between the parties to the conflict and the population affected by it, by restoring accountability and sanction mechanism. So the traditional concept of transitional justice often focuses on managing conflict without disrupting the pre-existing order in their society. The transitional justice mechanisms are primarily based on different branches of international law that impose obligations mostly on states. Nevertheless, in this constellation of international obligations and accountability, it is the individuals who are prosecuted before international criminal courts, as Nadia just said, and not the states, and certainly not the corporations, as Nadia also just announced. Because it's the state's obligation to investigate and prosecute that drives the transitional process, the traditional approach to transitional justice attaches the various truth-seeking mechanisms to the state and formulates what seems to be the justice from above, whether the truth-seeking is addressed through criminal or civil proceedings, or call for institutional reforms that require the involvement of the state. Due to the state-centric approach of international law, most of the fact-finding missions are also focused only on states, although this is slightly starting to change, as Irene pointed out in her book. And so mostly the non-state actors are excluded from any documentations and fact-finding investigations. To the extent that corporations play a fundamental role in armed conflict, documenting their wrongdoing is directly related to the truth-telling and, of course, dealing with the past. Now, what is the contribution to the truth-seeking by people's tribunals? In 1967, philosopher Bertrand Russell set up an official war crime tribunal called the Russell Tribunal to investigate United States of America abuses in Vietnam War. This was not the tribunal based on a treaty, but on the group of prominent people invited by Russell. Since then, there were many other initiatives inspired by the Russell Tribunal, including Prominent People's Tribunal based in Rome, what's called the PPT. All of them are addressing issues that receive very little attention by international community, or they are inadequately treated by formal institutions and procedures. They addressed a variety of issues in over 40 sessions around the globe. The Russell Tribunal is therefore an early instance of transitional justice. It functioned decades before the official discourse on transitional justice appeared, and it can be seen as practice avant la lettre. There are three sessions that were particularly interesting in our discussions today in the context of corporate liability. First, the Russell Tribunal on Palestine that holds second session in London on corporate complicity in Israel's violations of international humanitarian and international human rights law. The second one is International Monsanto Tribunal, organized by the civil society to clarify our legal obligations of Monsanto Corporation. And finally, the Permanent People's Tribunal, the PPT, that holds two sessions on transnational corporations in Southern Africa. First session was in August 2016 in Manzini, Swaziland, and second in August 2017 in Johannesburg. I will just say a few words about the common characteristics to most of the people's tribunals, because they all are specific to each context, so they vary in many aspects, but there are some elements that are very common to all of them. And there are mostly two. First is that the voice of people they represent, and they are victims originated. So in a way, they present the justice from below, which gives them a certain legitimacy. Courts of opinion aim to create a framework for victims and civil society to deal with violations of international law. They chart the course for alternative legal developments where the people are at the heart of the proceedings. The objective of this course is to reveal the truth and to serve a justice which must allow reconciliation. And at the same time, these courts seek to give voices to victims, but also offer legal solutions to enable them to obtain reparations. In this regard, they stand out from state justice and appear as a mechanism for establishing truth and reconciliation as an alternative to international and traditional transitional justice. The lack of connection with the state allows the court of opinion to derive their legitimacy from the people's will. Indeed, the people must initiate the procedure and search for certain truth, as well as the search for the protection of their rights and interests. As a result, people are seen not only as victims of violations of international law, but also as real subjects of international law, holders of rights. In addition to people, it is the individual victims who are stakeholders in these proceedings. And what is more, the victim is understood in a broad sense because human rights can be seen as rights belonging to individuals within a community, and thus their rights be attached to the community itself. Therefore, individuals, just like communities or indigenous people, can avail themselves of these rights. The second common element to most of the People's Tribunal is that these initiatives give preponderance to the law, and in particular international law. People's Tribunals criticize pure legalism that does not take sufficient account of social aspects and is too state-centric. This criticism is expressed in reference to the law. They don't dismiss the law, but in contrary, these courts adopt the legal vocabulary, appropriate the law to themselves, and claim the power to interpret it when they exercise functions which they describe as judicial. The reference to criminal law is moreover obvious, because it is the jury which renders advisory opinions or results after having put on a trial companies or states on the basis of the presentation of evidence and appearances of witnesses. They can therefore declare a state or a company guilty. And in this respect, they are a form of criticism of Nuremberg trials that prosecuted only individuals while they knew there was a very important corporate contribution. And they differ from international criminal trials in that they investigate state and corporate crimes. The reference to law is adapted for each context. For Russell Tribunal on Palestine, it referred to IHL and humanitarian law, human rights law. The Monsanto referred to international covenants and other human rights instruments, while the PPT in Johannesburg took into account the exploitation of natural resources in the region and based its development on the right to development and the right to healthy environment. According to the judges on the Johannesburg session, it is the very existence of impunity that violates the right to truth and the duty to seek the truth, the right to justice and the duty to provide justice, and the right to reparation and duty to repair. The rejection of formalism has also enabled the non-lawyers to participate in the proceedings and members of the jury and to contribute to them through their expertise in fields other than law. In conclusion, the People's Tribunals constitute a critical approach to transitional justice, offering alternative mechanisms for responding to widespread violence that has the potential to set free the mainstream transitional justice from some of its constraints. The two could be complementary. Thank you.
Thank you very much, Elena, for this very insightful presentation. Our next speaker is Jonathan Kohlhepp, who is a senior lecturer in law at Graduate School of Business and Law at MIT University in Australia, where he also serves as Peace and Conflict Cluster Leader at Center for Business and Human Rights. He has acted as legal consultant to the UN Office of the Special Representative for Children and Armed Conflict, and Jonathan's current project is on the legal protection of children in armed conflict and the human rights obligations of transnational corporations operating in conflict-related areas. Jonathan, we are delighted to having you. Thank you very much for joining us.
Thank you. Thank you, Katja. Can you hear me okay? Yep. And thanks to Irene for such a great piece of work. Thanks both for the invitation to participate. I'd like to begin my remarks by acknowledging that I'm joining from Melbourne, Australia, and in particular wanted to respectfully acknowledge that I join you from the unceded lands of the Bunurong people of the Kulin Nation, the first peoples of this land I'm on, and pay my respects to their elders, past, present, and emerging. Irene, what a joy it was to read your work. Congratulations and bravo. On a personal level, the tyranny of distance that us Aussie academics are acutely aware of has been replaced with the tyranny of time zones. Nevertheless, it is more easily overcome, especially with a cup of coffee in hand. So thank you for the opportunity to be part of this conversation. Permit me to say, it's been a tough year for all of us. We are in Australia, we are just emerging from our COVID lockdown. We see what's happening over where many of you guys are joining us from, and I hope you too will be able to get to the other side soon. Okay, so to the job at hand. Katja suggested I focus my remarks on institutional reform, and conveniently that relates to chapter 7 of Irene's book, Institutional Reform. I thought what I'd try and do is bring out a few highlights of the chapter that jumped out at me and also offer some provocations along the way. As Irene points out, institutional reforms is one of the 4 pillars of what the United Nations considers as constituting transitional justice, alongside truth, justice, reparations claims, discussed by my peers here tonight. The first thing I wanted to point out, as Irene does, is that there's a significant difference between institutional reforms and the other elements of transitional justice, in that it is inherently forward-looking. While the abuses of the past, the conflict of the past may be the impetus for launching reforms, the reforms themselves are future-focused, preventative in design, not about repairing or addressing corporate past abuses, but future ones, to prevent a recidivist slide back into violence. Institutional reform is important because the entrenched institutional inequities and fragilities are often prime drivers for and consequences of armed conflict in the first place. This makes a transition, a sustainable transition, really, really critical. I should add, especially important in the context of business and human rights. Yet, as Irene points out, this vital element of transitional justice is least explored in the academic literature and applied in practical initiatives. Why? Well, a few observations. Rebuilding institutions is hard, right? In other conversations, that's sometimes referred to as nation building, and we collectively are not very good at that. It also, institutional reform lacks the same tactileness as addressing explicit and specific rights abuses of the past through corporate accountability or reparations. There's also the suggestion made in the book that the demands for economic development also get in the way of effective institutional reforms during transitional justice periods. Yes, I'm happy to accept that, readily accept that, and also want to double down and suggest that oftentimes it's the economic development comes from attracting foreign investment, and that in turn is often perceived by local governments as requiring a loosening of social and environmental and rights regulations. Indeed, Irene points out that bilateral investment treaties, BITs, often favour corporate interests over human rights. Finally, the direct and indirect involvement of business interests in the loosening of such regulations should also be acknowledged. Okay, institutional reforms. Institutions. Which institutions are we talking about that should be reformed in this transitional justice context? As Irene points out, institutional reforms is frequently reduced to legal and judicial reforms, reflecting a classic state-centric approach. And Irene sort of takes that same approach okay, but I'm wondering what a broader understanding of institutional reform may look like. A broader set of institutions. One that absolutely encompasses government, the legislative, judicial branches, but other entities as well, such as regional and global institutions, the UN, and in the context of business, the World Bank, the WTO, the IMF, the ADB, and other development banks. These institutions too could and should be the focus of reforms in terms of their policies and practices within the context of transitioning countries. Again, and for our purposes and for simplicity's sake, having greater attention on human rights protections in the business projects that they support through loans or other direct assistance is what I had in mind. I also want to suggest that other institutions may warrant reform in the context of business, human rights, and transitional justice. For instance, civil society organizations and foreign governments, the home states of multinational companies, a la the French duty of vigilance laws, which Irene also refers to. Businesses, though, are also institutions, perhaps warranting reform in the context of transitional justice. Business schools are also institutions, and I think a very compelling case can be made for reform of business education to better embrace human rights, especially in transitioning societies. Let me test your willingness to play along this institutions game further and suggest institutions in the context of transitional justice is more than just organizations or entities, but could be thought of in a more conceptual sense as patterns of behavior within a society, the conventions, the traditions that are followed. Some are embedded in particular organizations, reflected in the laws and regulations, others not. These too warrant attention. Taking this broader approach perhaps would allow us to look for methods of reform beyond the traditional law reform approach as well. How to change behavior. Yes, law can do that, but there are other mechanisms too and other societal actors to co-opt in that effort, including businesses themselves, changing institutionalized notions of race, sustainability, and human rights. Also, given the audience, we could be contemplating public international law and lawmaking as institutions themselves, also sites of potential reform in the context of transitioning countries. Okay, so that was the which institutions we're referring to in terms of reform in transitional justice context. I also wanted to tease out the what. What reforms are we seeking when it comes to business, human rights, and transitional justice? Irene goes through a fair few examples: more equitable land laws in Myanmar, strengthening rights protections in the Nepalese and South African constitutions, reforming natural resource governance in Sierra Leone. All are great on paper, but as Irene points out, the harder part is implementation. We do need to be wary of any potential perverse results. In some contexts, such reforms could prompt companies to shift economic activity away from post-conflict societies where it is much needed and continue to do business as usual elsewhere. So I think it's important to have a holistic, a global approach, a regional approach when pondering institutional reforms to achieve better outcomes in specific transitional justice contexts. Another aspect of the what, yes, I think the substance and language of human rights is obviously super useful when contemplating what institutional reforms are appropriate in transitional justice settings. But permit me to also suggest institutionalized efforts to embed human rights should incorporate international humanitarian law as well, referred to by others as well already earlier. Why? Well, knowledge of IHL is often lacking. And if the unfortunate happens and there's a slide back to violence or outright hostilities, such reforms may prove beneficial, for instance, encouraging some modicum of humanitarian restraint. My final point, framing and scope. The framing of the discussion tonight and in Irene's book is insightful. And here I think Irene and I diverge somewhat. The chapter frames the institutional reforms required as preventing reoccurrence, to prevent future corporate human rights abuses. absolutely that is appropriate aspect. But the conversation around institutional reforms and transitional justice and business more generally should not solely be confined to corporate accountability in post-conflict settings. The relationship between business and human rights is more than merely accountability for wrongdoers transgressing rights rules. Businesses can and have and do also uphold and champion rights. This holds true in the transitional justice context as well. Yes, abuses should be addressed, reparations acted upon, truth should be outed, corporate accountability for past abuses, and future corporate rights abuses prevented. Absolutely. But what are the positive contributions the business community? Yep.
Jonathan, sorry, I think you should need to try to wrap up and moving closer to finishing.
My final sentence, Katja. What are the positive contributions the business community may make to transitional justice processes? What is the role of business in encouraging, even facilitating institutional reform and ultimately achieving the future of justice that we seek? I see tremendous potential on that front too.
Thank you very much. And apologies for reminding about the time. We have so many panelists today that want to make sure we go to everyone. I can already see the questions popping up as well. So we are moving now to discussing some regional expertise and regional insights. And our next speaker is Maha Abdallah, who is an international advocacy officer at the Cairo Institute for Human Rights Studies, a regional organization seeking to promote human rights in the Arab world. Formerly, Maha was a senior legal research and advocacy officer at Al-Haq, a Palestinian human rights non-governmental organization which has received the Human Rights and Business Award last year at the UN Forum on Business and Human Rights. And Maha's research and advocacy focuses, among others, on questions relating to corporate accountability, business and human rights, and conflict-affected areas. Maha, we are delighted to having you. Thank you very much for joining. The floor is yours.
Thank you so much, Ekaterina, and congratulations, Irene, on the launch of your new book. I look forward to reading it. I'm going to give some insights coming from the Middle East, focusing mostly on Palestine, as that's the area that I'm most familiar with on this topic. And in this region, we have seen how corporations have been evidently involved in human rights violations, grave breaches of international law, and in further empowering and nourishing repressive and authoritarian regimes, occupying powers and perpetrators of crimes through arms sales, security and censorship technology, exploitation of natural resources, and much more. And unfortunately, without much national or regional accountability mechanisms or remedy afforded to those affected. For example, looking at Syria, international and local corporations have been involved in serious violations in the Syrian conflict, whether through the provision of surveillance equipment to the Syrian government, resulting in the arrest and torture of protesters and other civilians, or in the provision of financial resources to armed groups perpetrating crimes and crimes against humanity. At the same time, in Yemen, we have seen the role and involvement of arms companies, Italian, German, British, American, and others in the war for more than 5 years, resulting in the killing and injury of thousands of civilians and the destruction of vital infrastructure as a result of indiscriminate and disproportionate attacks. And these companies not only make profit, but they also fuel and allow the parties of the conflict to continue the war. And this is a scenario that we see in so many other places, whether in the Middle East or around the world, unfortunately. And then in Palestine, when we look at corporate involvement, we see it very much manifested in Israel's occupation, which comes in different ways, whether it's population control, economic exploitation and subjugation, and the illegal settlement enterprise in the occupied Palestinian territory. And zooming in at the illegal settlement enterprise, hundreds of Israeli and multinational businesses have been contributing, maintaining, and facilitating its growth by providing job opportunities that encourage Israeli settlers to relocate into occupied territory, contrary to international law and amounting to a war crime. its businesses are also contributing by supplying construction equipment and materials, supplying surveillance equipment and security services, providing transport, banking, and financial services, exploiting occupied land and natural resources like water, for example, all for the benefit of the occupying power, its citizens, and the economy, at the expense of the occupied population, again, contrary to international law. And the systemic and persistent nature of these violations that corporations are involved in Palestine, combined with the prevailing culture of impunity and the lack of political will from the international community, as well as the lack of regulatory frameworks for corporations more broadly, especially in such contexts of conflict and occupation, has often meant an accountability gap, or gaps actually, for perpetrators and those that are complicit. And although different mechanisms have been used over the years to counter corporate involvement in the occupation in Palestine, like systems of monitoring and documentation, litigation cases in home states, OECD complaints and advocacy efforts at international mechanisms like the UN and others, and despite some successes here and there, the trend of, let's say, irresponsible business conduct is still there, and it is facilitated and supported by states' action and inaction, and therefore it continues to contribute to an illegal situation and grave violations. However, one of the most recent tools to slightly shift this, let's say, is the UN database of businesses involved in Israel's illegal settlement enterprise, which was mandated by the United Nations Human Rights Council resolution in 2016. And the first version of the database was published this year in February, listing 112 companies, both Israeli and multinational, that are linked and involved to the settlement enterprise. And this database has been very important because it identifies and lists businesses that are directly or indirectly violating international law in their operations and relationships with the settlement enterprise. So it's seen as a tool of transparency that could help prevent companies from being complicit or involved in such violations. It is also important because it may require eventually home states of multinational corporations to revisit their relevant domestic legislations and laws to ensure that businesses within their jurisdiction are not involved in such illegal entity. Also, that comes in accordance with the state's duty of non-recognition and non-assistance under international law, very relevant to this context in Palestine. And also such a UN database is viewed to serve as a model for business enterprises that are involved in and profiting from political instability and armed conflict. And since we've mentioned Myanmar so far in the discussion, looking at the 2019 fact-finding mission report on Myanmar, it also exposed military business ties and called for the targeted sanctions and embargoes. And although the UN database remains to be a relatively soft mechanism, let's say, for corporate accountability in Palestine, its effects have already been felt, even before its publications, I would say, to the extent that it faced a lot of backlash and threats by powerful states and attempts to try and diminish it and undermine it. Yet civil society has put so much efforts to make sure that it sees lights and that it continues despite all these obstacles because of its importance. And the database, just to mention that it's something that should be annually updated and that we would hope to see more companies listed in the coming years. But also we would hope that other companies would be removed because they would have stopped dealing with and operating in illegal settlements. And I think this is another added value of such a database. And lastly, I want to close with two final points regarding corporate accountability more generally and from the experience that I have engaged with. The first point being that it is of really high importance to center any accountability mechanism or avenue on those who are directly affected on the ground and where they would be or are the driving force and reference point for any action and decision in the process. And the second point that I would also like to stress is that it's always important to remember that for many communities and peoples, Avenues of corporate accountability are not only used to counter one company or two, but also an entire system of domination, exploitation, and repression that has been imposed against them. And in some contexts, it comes as part of a broader process of decolonization, liberation, and realizing the fundamental right to self-determination and permanent sovereignty over natural resources and others. And this is something very important that we have to keep in mind and center as well in our approach and work in this field. Thank you very much.
Thank you very much, Maha, for this very important points that you've made. We are now moving to African perspective, and our next speaker is Dr. Owini Ape, who's a research fellow at the Center for Comparative Law in Africa at the University of Cape Town. He has published extensively on oil and gas law, the intersections of business, human rights, and environment, as well as provided expert advice and opinion on extractive industry's law in Africa. Dr. Ape is currently investigating how constitutional and governance organizations can create transformative change for the people. Thank you very much for joining us, and we're looking forward to hearing from you.
Thank you very much, Katerina, and the Oxford Business and Human Rights Network for planning and organizing this panel, and congrats for inviting me, and congrats to Dr. Irene Petropoli for a masterpiece book publication. And with respect to transitional justice mechanisms in Africa and the potential for corporate accountability, I'll start off by making a more generalized statement that virtually, if not all, African countries are still societies in transition. And this is based on the benchmark of the realization of socioeconomic, cultural, and political variables. But it's not possible for me within the time frame to speak on all the countries in Africa, but I'm just going to pick some examples of how transitional justice mechanisms, corporate accountability has been achieved. And I'm going to focus on two factors or 2 points. It's the adaptation to local realities and the issue of corporate criminal liability. But this notwithstanding, in post-conflict Africa, it appears the experience has geared more successfully towards restorative justice, even for corporate accountability. We're increasingly seeing a move from the dominance of retributive transitional justice towards new models of restorative justice. And this raises quite a number of questions about the helpfulness of truth commissions in providing accountability for corporate human rights abuses. One of the difficulties and technicalities associated with these truth commissions or transitional justice mechanisms in Africa is that reconciliation was largely conditional on truth-telling and the perpetrators being honest rather than explaining why they happened or preventing their reoccurrence. We all know that one of the difficulties in achieving justice for corporate human rights victims is that corporations refuse or deny responsibility for their acts. And this is one issue that doesn't sit well with victims or local communities who are victims of these human rights abuses. And some of my interactions with a good number of these local communities, the first thing they say is, accept the fact that this was caused by you. We're even fine with that, even without reparation or without a form of justice, just accept that you caused it. But most times you see companies actually labeling these local communities saboteurs, sabotaging their work and activities and actions. And so in South Africa, and Irene did a masterpiece in looking at the South African Truth and Reconciliation Commission, Desmond Tutu's work, so I won't really focus more into details about that. But one thing I would just say is that one of the weaknesses of the commission was that it granted amnesty to perpetrators of crime as a form of forgiveness, not as punishment or deterrent mechanisms for perpetrators, including corporate entities. And because of these, and then we saw that most company executives, which are mostly white, did not even appear before the commission. And this didn't sit well with most of the victims who are the receiving end, who are mostly the Black majority. And these inadequate or inherent inadequacies led to a series, the institution of the South African apartheid litigation, the Kulumani case, in the US, which was a case that arose out of activities of US companies operating or supporting manufacturing equipments and aiding and abetting the apartheid Afrikaner government in South Africa. But what happened, the decisions which didn't succeed actually, it was well explicated in the book as well. And but the intriguing part of that story was the fact that on appeal to the US Supreme Court, they brought the subsidiarity principle and said that even though these were American companies, but the subsidiary companies were actually the ones involved in these human rights violations, and therefore the US court could not adjudicate over the matter. So in addition to the silicosis case as well, which was recorded in the book, another case which was also brought out the resultant effect of the failure of this Truth Commission is also the Marikana incident in South Africa. So in 2012, about 44 people, mostly minors, were shot and killed by the South African police security forces. And this involved the Lonmin, which is a UK platinum mining company, which has already been purchased in 2019, was purchased by South African based firm. And after the killings and the violence that erupted, the government commission, as usual in most African states, the government commission on inquiry was set up by the states to look at the Lonmin's policy, procedures, and practices. Now, under the Minerals and Petroleum Resources Development Act of South Africa, any company that's going to be involved in extractive industries must develop a social and labor plan. So which is usually bringing out how to mitigate, prevent human rights or any environmental effect of all the activities. And it was discovered that in carrying out this investigation, a major consideration before the commission was Lonmin's failure to implement its social and labor plan and the contributory role this played in the Marikana crisis. So the company agreed to convert existing hostels into bachelor or family units and to build an additional 5,500 houses for their migrant employees. The houses were supposed to have been completed a year before the Marikana tragedy took place. And the company's chairman actually acknowledged the fact that in the company's first annual general meeting, that events that led up to the tragedy reflected the breakdown of trust between the company and its workers. Now, the Commission of Inquiry found that Lonmin's failure to comply with its housing obligations created an environment conducive to the creation of tension, labor unrest, disunity among his employees or other harmful conduct. Now, despite Lonmin's behavior and despite the Commission of Inquiry's decision and the recommendation of the Commission, the state did not sanction Lonmin. Neither did it cancel Lonmin's mining license, which brings to fore the issue of why did you set up a Commission of Inquiry in the first place? In order to heal the wounds of the past and to move forward. And again, and I would like to construct, and speaking on the first point of adaptation to local realities, I would like to contrast this with the Rwandan case, so which is not usually talked about in this true transitional justice mechanisms pace. So post-genocide Rwanda, and because of the so many cases in terms of finding justice, Rwanda adopted a community form of justice, which was known as the Gacaca court system. So in order to deal with the administration of justice, the government established a traditional Gacaca court system. So this participatory justice system of Gacaca was an important move in the restorative justice paradigm. It was mainly created to lessen the burden on normal courts and provide assistance in the justice system. But I must quickly add that even though the Gacaca court system didn't really take over cases of corporate accountability, but the fact that it actually sat well with the people, this was a kind of justice that adapted to local realities, and the people saw as a more informed, suitable form of redressing justice rather than the court system or an international criminal tribunal. Goes well to say that any truth commission setup must actually understand what the people want and to heal the wounds of the past. So, so despite the concerns about this form of justice, the Gacaca court system offers a veritable alternative to other forms of criminal justice system. In fact, about 2 million cases were heard by the court system compared to the International Criminal Tribunal, which I think had about 96, indicted only 96 individuals. In Nigeria, we had the Human Rights Violation Investigation Commission, otherwise known as the Puta Panel Report, which was set up by then President in 1999 after Nigeria returned to democracy. to investigate human rights violations. Now, when the panel was set up, there were allegations against former military heads of state. For one of the cases that came up before the panel was the military head of state for masterminding the assassination of high-profile individuals, including Ken Saro-Wiwa and Shell Corporation. Now, neither Shell or the executives of Shell appear before the panel. But again, even despite the report of the commission, the recommendations were never carried out by the government. So it appears as these truth commissions were hardly put in place to truly heal past wounds and restructure the country, but put in place to address some narrowly defined interests of the ruling elites. And I'm going to conclude by focusing on the second point, which is on corporate criminal liability. To an extent, I believe prosecution goes a long way in terms of name and shame, the actor's responsibility, and there's some cases that shows reluctance of Africans to be subject to or participate in any transitional justice mechanisms due to the level of distrust in the process and the non-deference to local objectives, which I just explained. So when domestic laws are weak, a regional justice system becomes imperative for victims of human rights violations. In Africa, there is no one comprehensive framework on the continent. Just recently, the African Union developed an African transitional justice policy based on its shared values and elaborating a wide range of indicative elements of transitional justice. But despite that, so that's why I believe that regional criminal justice would go a long way in actually finding corporate criminal liability. And with this regards, the protocol and amendments to the protocol on the statute of the African Court of Justice and Human Rights, which is otherwise known as the Malabo Protocol, becomes instructive. Where the African Union adopted this protocol in 2014. If duly ratified, the protocol will expand the jurisdiction of the African Court of Justice and Human Rights and consequently establish the first regional criminal court in the world to adjudicate cases of corporate criminal responsibility. And this is based on a number of factors. 2 points, and finally 2 points. And the first is that the legitimacy of any court is affected by public perceptions of it. So if truth commissions are seen as more of actually not in a way to finalize or heal the wounds of the past, then prosecution can be seen as a way for companies to actually compel them or mandate them to pay, quote unquote, to pay for the sins which they've committed. And secondly, the principle of extraterritorial application of cases has not been very quite successful in Africa. And that's why you see at domestic level. And that's why you see the Vedanta case, the Kyobel, the Nelson cases are decided in home states of this company. So perhaps a regional criminal court could be the solution you've been looking for, and could create an awakening of responsibility for local actors to ensure that their companies, and if companies do know that even if they can escape justice at domestic level, they will be taken to a regional court, a regional criminal court, which is international in outlook, then I think to an extent we can be satisfied that transitional justice mechanism of corporate accountability in Africa is a thing we can be proud of. Thank you.
Thank you very much for this very interesting discussion. We are now moving to Marco Velasquez Ruiz, who is a Colombian lawyer who will share with us some insights from Colombia. Marco served as assistant magistrate at the Colombian Peace Tribunal. He has extensive experience as a consultant to various national and international organizations. And in addition, he has lectured and researched on various themes within today's topic. Marco, we're looking forward to hearing from you. Thank you.
Thank you very much. I would like to start by thanking Ekaterina for the kind invitation to join this panel, through which we celebrate Irene's book and its contribution to a great number of academic fields and currents, including both business and human rights and transitional justice. In order to do so properly, I will briefly introduce some insights on a series of mechanisms that are currently being implemented in Colombia on the occasion of a comprehensive transitional justice project that might be considered as prone to advance on the effective achievement of corporate accountability. We must remember that the country, Colombia, has gone through decades of an internal armed conflict that jeopardized Colombian society, particularly rural and ethnic population, and that the causes of which are identified with social discrimination patterns and structural inequalities. In this regard, it has been established that certain corporate actors, especially those coming from economic sectors such as agribusiness, infrastructure, and mining, performed a decisive role in the configuration of the associated dynamics of violence that took place around their spheres of influence. This in order to benefit from the consequent processes of forced abandonment and dispossession of land and natural resources. As a response to this situation, for the last 10 years and on the occasion of a peace process that arrived at an ambitious accord in 2016, Colombia has been implementing a comprehensive transitional justice project. As its principal aim is to place the victims at the center of concern, the project has implied the development of a specialized set of norms, institutions, and processes. Seen as a whole, the latter are considered as an articulate system that seeks to meet the victims' expectations from the standpoint of their rights to justice, truth, and reparation, and non-repetition. It could be said that the Colombian experience has compiled some of the best practices of previous transitional justice efforts taking place globally, and processes that have been commented by my fellow panel members, in order to adapt them to the particularities of the situation addressed, the particular situation of Colombia, the one I was just mentioning. Now, it seems that within the realm of this transitional justice project, corporate accountability is progressively becoming a fundamental topic of both discussion and institutional development. The work conducted on understanding the factual circumstances underlying the situation of internally forced displacement, for example, revealed that, as I just mentioned, corporate actors were somehow determinant in the conflict, promoters of violence, beneficiaries of violence, and even non-diligent structures that clearly had the possibility to know what was happening and to perform accordingly, to say the least. The Colombian project has recognized such situation and consequently responded by disposing institutional scenarios for corporate actors to both give an account of their role in the conflict and advance on restorative-oriented actions in favor of those affected, directly or indirectly. In the first place, it is important to mention the land restitution procedure, including in the Victims Act that was passed in 2011. This regulation was necessary to both respond to the imminent reparatory needs of the victims and legitimize the incipient peace process with the guerrilla group FARC. Hence, land restitution was conceived as an effective mechanism to intervene the material and legal status of cadastral rurality, so as to adjust the social relations that were affected by means of violent acts associated with abandonment and dispossession. Sooner than later, it became apparent that the decisions being taken by the transitional land judges were affecting the rights and economic expectations of corporate actors that, on the occasion of the situation generated by the conflict, accessed to both lands and concessions to perform entrepreneurial activities in such territories. Although it must not be considered that as a retributive-oriented action against corporate actors, but as a territorial intervention, land restitution has proven to be relatively effective in generating external costs, unpleasant consequences on those who took advantage of the armed conflict to articulate their interests upon regions severely affected by the widespread violence. After almost 10 years of implementation, it has become clear that the potential of this policy escalates in the case of the claims exerted by ethnic groups, which have focused on great extensions of land and juxtaposed with huge economic projects owned by foreign investors regularly. Unfortunately, the latter have pushed the state to restrict the scope of land restitution in various and repulsive ways. Now, in parallel, the Colombian Transitional Justice Project aims to provide judicial remedy to the crimes committed on the occasion of the armed conflict. Therefore, in 2016, the peace agreement provided for the creation of the Special Jurisdiction for Peace, or HEP. In spite of the great opposition exerted by part of the Colombian society, this mechanism, the HEP, opened the possibility to study the situation of civilians linked with corporate actors, known as private third parties, who are pointed for their alleged relation with human rights violation and international crimes on the occasion of such link. Although the appearance of private third parties before the HEP takes place under a voluntary basis and does not include corporations directly, it starts to be seen as an opportunity to facilitate corporate accountability. This is so since, in order to be accepted and access beneficial sanctions, if compared, of course, with ordinary criminal penalties, they must provide a comprehensive program of truth and reparation that directly addresses the situation of the victims, of the linked victims. This program, framed within the label conditionality regime, must be discussed with them in order to count with their consent and subsequently be approved by the tribunal, which must consider whether it has a long-term restorative impact. While we get to realize whether this prospective avenue for integral reparation gets enough social support to consolidate as a sustained process of corporate accountability, even if that happens because of that cost-benefit calculation, it is undeniable that HEP's conditionality regime represents an alternative to address some problems identified in previous transitional justice instances, such as truth and reconciliation commissions in which effective corporate accountability was not feasible due to the abstract or non-prescriptive character of the conclusions and recommendations therein issued. Last but not least, to leave some space for questions, the Transitional Justice Project's very own Truth Commission was structured as an instance of social dialogue, rather than a mere producer of a report. In this regard, the Colombian Truth Commission seeks to promote the conduction of processes focused on promoting recognition of what happened in the conflict by the concerned actors, including corporate actors, schemes of coexistence in the territory with the direct involvement of businesses, and finally, the production of recommendations oriented to promote non-repetition of conducts and dynamics. So that would be all. Thank you very much.
Thank you very much, Marco. And there are definitely some points to be picked up during Q&A session, and I'm sure you'll address them. We are moving actually to Q&A now, and what we'll do is I'll read questions that we have received. There are a few of them in one round, and then we'll give floor to our panelists to answer the selected questions. So there was a question for Irene about Syria, that corporations that are complicit of funding the Syrian regime, and whether you cover these questions in your book, and what are your thoughts on the non-recurrence, guarantees for non-recurrence. There was also a question for Nadia, and I think Irene could also pick on that, whether funding transnational justice processes by the complicit corporations could be an option and how it could work in practice. There was a question to all panelists. What do you think economic incentive structures play in the viability of transition to justice, where economic interests play a driving force? We also have an interesting questions about the existing tension that many states lose in human rights protection to attract foreign investment in post-conflict countries, which later on has an adverse impact on the future human rights violations. What are your thoughts on that? We have two questions specifically for Jonathan. The first one was about the international organizations and international development banks. You mentioned that they need to be careful while choosing whom to give a loan. So do you think we would benefit, international law could benefit from some sort of guidelines? And do we need these guidelines, and how they will be working in practice? And another question for you was that you mentioned you were positive on business community. Could you give some examples or reasons about that, specifically in light of some of the points that were made? We have a question for Irene. So you mentioned the proposed incorporation of transitional justice pillars by the guiding principles for business in conflict areas. Do you think this is enough? We have a question for Dr. Abe. Does the corporate capture of states in weak governance zones have any impact on the outcome of Truth and Reconciliation Commission reports? And do you think this might have had an impact on the outcome of the Marikana Inquiry Commission? And finally, I will also take the question for Nadia about the corporate criminal liability recognized by the African Union Malabo Protocol and the Statute of the African Court of Justice and Human and People's Rights. What do you think on that? So there are a few questions. Our panelists can see them, so they will pick up on the ones they choose. I think I will give floor first to Irene, and then we'll go one by one. Thank you.
Yes, thank you, and thanks everybody for the very, very interesting question. I wish we had more time to discuss afterward as well. But to answer quickly both questions from Mansour, because they kind of related to similar points. Yes, of course, the Syrian regime has a long history of twisting their laws to empower business, and that's a result also in corporate involvement in violations. Exactly the same that I witnessed in Myanmar, and it's the same situation in many other countries. So your point of looking into other aspects, not only prosecution, but institutional reform, guarantees of non-recurrence and reparation is very important. I actually think that institutional reform has like the most important role to play in transitional justice, especially in this area of corporate accountability, because they are forward-looking and aim to achieve non-repetition of violation. So in relation to institutional reform, and also linking to what Jonathan was discussing, preventing corporate human rights abuse require changing the state structure and institution that facilitated or failed to prevent abuses and allowed business to participate or benefit from human rights violation. So institutional reform need to address the institution that are part of the economic development paradigm. So, for example, those regulating investment, then governance, ensuring that go beyond simply enabling market activities by including procedural safeguards and accountability mechanisms. But we know that the neoliberal temptation to deregulate, privatize, and rely on investment has inhibited many governments from doing so, you know. And in relation to the point on reparation, this actually, we didn't have today with us Tara, Dr. Van Ho was going to talk about reparation, but this is like another chapter of the book. I focus on land restitution. I just choose to that point, but in general, I think that administrative reparation programs can provide a variety of measures for violation related to business activities, because they could provide reparation for all classes of victims rather than in response to individualized justice, so through the courts. New programs, reparation program in relation to, you know, that they attempted to redress corporate abuses have been attempted, especially in the area of land restitution. And for example, Colombia, as Marco mentioned, I know very well, is attempting an innovative land restitution program under which some company may be forced to return land obtained during the conflict. On the point that Daria, I think, made in terms of incorporating the 4 pillars of transitional justice into the UN Guiding Principle, yes, I don't think that's enough. For sure, that's not enough to solve any of those issues that we are mentioning in full. But it is an important step, because the guiding principle did not mention transitional justice at all. Overlook, I think, in general, the issue of corporate involvement in conflict, because they only have like one very short mention of corporation operating in conflict and about having enhanced due diligence. But I think that this issue it will be quite key, because the most serious human rights abuse by company happen in situation of conflict. So having at least the a business human rights framework, so not just the UN Guiding Principle, but the entire framework, incorporating the principle of transitional justice will be a first step to address some of these issues.
Thank you very much. Jonathan, there were 2 questions for you specifically, if you want to pick up on them. Thank you.
In 30 seconds or less. Okay, yes. So there were two questions. I mean, I'll associate myself with Irene's remarks just then too. So there was one about international funding organizations, development banks, and there was one about positive aspects of business in transitional justice. I'll refer you to, there was a 2015 UN report by the UN Special Rapporteur on Poverty, Philip Alston, who declared very famously the World Bank is a human rights free zone. In the Constitution, in I think they call it the Articles of Association of the World Bank, it says that all decisions have to be based only on the economic matters and no interference in political affairs of states. So that's always where they're going. But there is movement. There are various, there's the Human Rights and Development Trust Fund that the World Bank set up. There's the Multilateral Investment Guarantee Agency that does have some performance standards. And right now, as we speak, there are 450 development banks meeting in Paris talking about climate change and rights as well. In regards to being positive on business, so I'm not, corporate accountability is absolutely a part of business and human rights in transitional justice settings. I'm only seeking to add to that. For example, I think generalizations are fraught in any conversation. Business is not homogeneous. Think, for example, about small and medium-sized enterprises. Local enterprises in these conflict settings are sometimes amazing drivers of economic activity. They are part of the business and human rights conversation. I was recently in Mindanao, an amazing group of women setting up coffee plantations and a coffee business, hiring locals is just, I think, a fantastic example. Another example was actually in Myanmar. I believe a lot of Western brands of clothing companies actually campaigned and advocated for an increase in the minimum wage, even as other apparel manufacturers did not. So that's an example of businesses doing good things in the human rights space. I'll leave it at that.
Thank you very much. There was one question for Dr. Ape, and Oni, I'm giving you the floor now. It was on the whether capture of states in weak governance zones by corporations have impact on the outcome of truth and reconciliation commissions.
I'm sorry. Yeah. So yes, I mean in South Africa, there's what they call state capture, and in terms of transitional justice context in most African societies, there's also corporate capture. So the reality of the fact is that, and I think this also fits to another general question, which I think somebody asked about economic incentive structure. The reality of the fact is that, like I said initially, that African society in transition, Africa needs development, right? So infrastructural development. And the question is, despite its huge and massive human and material, human resources, extractive resources, the question is, how do we leverage these extractive resources for sustainable development? So how do we leverage all the resources we have and guarantee sustainable development? And the question is, in most bilateral investment agreements, do we incorporate human rights provisions? And in fairness to some of these international organizations, the World Bank and I think some international financial corporations, they've actually come up with the borrower's responsibilities for accessing, I think, an assessment and management of environmental and social risk impacts. So which sets out the borrower's responsibilities for accessing and monitoring environmental and social risk and impacts associated with each stage of a project, I mean, which is supported by the bank through investment project financing. So even where the states are weak, more is needed on the part of corporate entities to ensure that they not only contribute to they do not contribute to human rights violations, but they actually enhance and uplift the local communities. And one of the areas of looking at this is through, like in the Marikana incident, the social and labor plan, which the law guarantees, but which LONMI failed to actually respond to. So one of the areas which people have been, researchers and scholars have been looking into is a social license to operate, or in some countries we call them impact benefit agreements, global memorandum of understanding. How do you incorporate your host communities at the very earliest time, and to create a kind of joint venture agreement between the companies and the host communities? So most of these agreements are signed between companies and states. So how do we involve the local communities? So the question could be having another agreement with the local communities, and that will actually circumvent the provisions of the idea of corporate capture of states in weak governance. So unless the voices of the host communities are heard, no matter the extent of international treaties or agreements or trade agreements that we sign, will continue to impact human rights in some of these weak zones. And of course, I do think the outcome of the Truth and Reconciliation Commission would have had an impact on the outcome of the Marikana inquiry, because most of these African countries, the companies are actually more powerful than the states. The revenue is much more, the political, in the case of Nigeria, for example, I mean, Shell is actually much more powerful than the Nigerian government. And in such instance, who do you think the state government would side with, the people or the company? So, but again, and that's why, thankfully, some of these home states of these companies are coming up with a lot of due diligence agreements or laws or regulations to actually ensure that when you go to these countries, especially in weak zones, you must, even if the states are not willing to enforce their laws, you must ensure that you do what is right. Because even in your own state, you cannot do some of the things you are doing in this country.
Thank you very much. We are running behind, but I'm going to give another minute for the remaining panelists so that they can either answer questions or just reflect. Nadia, there has been a question for you on African provisions as well. Thank you.
Thank you. Yeah, just very quickly, I had a question on the Malabo Protocol, and basically asking, I think, if I thought it was a good development, an important development, and what's the potential of this. So I mean, very quickly also, because we don't have a huge amount of time, to me, that's a very important development. In fact, it's especially important. I'm going to link that to another question I had about whether we should pursue including legal persons as potential defendants before the International Criminal Court. You know, I love that discussion. I've been thinking about it for many years. I've talked about it many times, but at the end of the day, I think concretely, I don't see that happening anytime soon. The challenges of amending the statute, we know it's possible, but is there any kind of willingness to go this route when we know the kind of economic, also the kind of economic actors that could be prosecuted at the court? I honestly don't see that happening, at least in the current context, in light of the current challenges of the International Criminal Court generally. So in that context, I think the Malabo Protocol, whatever it becomes also in practice, is an important development. I think it's also important because I see it as an attempt to sort of break the narrative about conflicts in Africa being only local and somehow unrelated to bigger economic interests. And we know that's not true. We know that most of these conflicts are related to resources. And when they are resources in a globalized economy, there are powerful foreign investors, foreign corporate actors who are involved. So I think it's very important, specifically in the African context, because that links back to the discussion about the ICC and Africa. It's extremely important that this was adopted. Now, whether that will have an impact in practice, I'm waiting to see that. Of course, I'm hopeful. I'm always hopeful. Otherwise, you're not in this line of work. But I see potential resistance, especially from states eager to secure and retain foreign investment, who might see the opportunity to prosecute corporations as somehow standing in the way of their own development policies. So that's always a concern. That, by the way, was also a concern at Nuremberg. And when the decision to not prosecute corporations at Nuremberg was partly taken with the idea that we needed German business people to be there to basically work towards the reconstruction of Germany and avoid Germany to fall into the hands of the Soviet side in the Cold War. So these discussions about sort of somehow sparing the business sector so that they can build and they can be present in the reconstruction. I mean, there's nothing new there. So in short, I think it's a great development. I'm waiting to see how it's going to work in practice, but at least the symbolic of it is very important. So I'm willing to support that irrespective of the actual outcome in practice.
Thank you very much. Maha, do you want to take 1 or 2 minutes just to reflect on some of the questions?
I don't have anything like relevant to any of the particular questions, but thinking through them, I think it's important to keep in mind that it's important to use and exhaust as much of available accountability mechanisms as possible, strategically, obviously, and not haphazardly, especially because, often these corporate abuses and involvement in violations are directly impacting the daily lives of people's communities, their life, their right to life, their well-being, their livelihoods, and all of these fundamental rights and needs. So I think it's important to try and seek all the availabilities and openings where we can, because as it is, the system is very complicated, very politicized in so many cases, and that is a problem, of course. Thanks.
Thank you very much. And Marco, if you have any comments and reflections, there has been a question addressed to you that Office of the Prosecutor noted with this examination of Colombia that about some domestic investigation. So whether you want us to pick up on this question.
Yes, Ekaterina. The question was a little bit difficult to understand, but I tried to elaborate on what I could get from the description of a case that is quite famous in the country, Chiquita Brands, which is an US-based company that somehow financed paramilitary groups in the 80s and the 90s in Colombia, and for which there have been both domestic and investigations taking place in the US. And as apparently the question goes around the fact that not every member of the top structures of the company were investigated within the domestic procedures. And additionally, it is asked whether rehabilitation or incapacitation would be effective actions to prevent businesses from engaging in criminal activities. I don't think whether pure criminal prosecution would be the way. In fact, the orientation that the Colombian Transitional Justice Project has taken is to create a hybrid institution, the HEP, which not only deals with the prosecution of the top responsible, but also thinks about the victims and puts the victims in the center of concern, which I think would be better for the purpose of preventing and achieving non-recurrence of these conducts. Possibly prosecution is necessary in terms of both achieving international standards in terms of human rights and criminal law, international criminal law. But if we think about population, if we think about the victims, maybe an alternative approach is also necessary, which is the one that I was just commenting.
Okay, thank you very much, Marco. And thank you very much to all panelists for this thought-provoking and very insightful discussion. There are many debates that were outlined. I'm sure they will be picked up later. And thank you very much to all of the participants who have asked so many interesting questions. I'm sure many of us will be joining the UN Forum on Business and Human Rights next week. It would be so lovely to see everyone in person, but for now we have to remain online. But congratulations again, Irene, on publication of this very important book. It's an excellent contribution, and thank you very much for joining today.
Thank you.
Thank you. And bye-bye for now, everyone. Thank you so much.
Bye-bye. Thank you.
Thank you. Bye.